Welcome back to our series of 52 weeks of personal injury, and this week is week 19, and we're going to talk to you about how much is pain and suffering worth, which we get that question a lot, right? Because pain and suffering is very hard to pin down. So Joel, what is the actual legal definition of pain and suffering?
The enlightened conscience of a fair and impartial jury.
So what does that even mean?
I don't know.
Right, a lot of people don't know, right? I mean, and that's true, right? Because pain and suffering is up to 12 strangers to decide what they're going to award for your injuries, right? And of course, there's ways to prove pain and suffering and ways for us to try to quantify pain and suffering. And one of those ways is obviously the severity of the injury, right? So if you're really badly hurt, if you've got a broken bones, you need surgery, you had surgery, all those types of things are going to increase the severity of your injuries, thus increase the amount of pain and suffering. So what's another way that or another, I guess, thing we look at when trying to discuss pain and suffering?
Yeah, so I think the most difficult thing about pain and suffering is it's an intangible thing that we're trying to assign a dollar value to, right? And the law is not real clear. It doesn't say, you know, if you have a 7 out of 10 pain because you broke your leg, that you get this amount of money.
Right.
That is the enlightened conscience of a fair and impartial jury. So we have to, as trial attorneys, we have to help the jury understand and give them some kind of guidance on what's fair and reasonable for this amount. So like you said, the severity of the injury, if it's something that hurts a little bit and you're fine in 2 weeks, the pain and suffering award is going to be fairly small. But if it's a 9 out of 10 or 10 out of 10 type pain and you suffer for a long time, I guess the second element that we would look at would be the length of suffering, then obviously the award for pain and suffering should be greater than it would be if the amount of suffering is smaller and the length of time that you suffer is smaller.
Right, and sort of in that same vein as the permanency, right? If you get a permanent impairment rating from your doctor who says, you know, you've got an 18% whole body impairment, meaning you've lost 18% of your bodily function, use of whatever limb it is that you've got injured, or your back, or whatever it might be. So that's another way to, you know, sort of, I guess, impose or impress upon the jury what the pain and suffering amount ought to be.
Yeah.
And you know, the legal definition is what enlightened conscience of a jury is, but when you go to trial, the judge reads what are called jury charges, and the judge gives kind of examples of what you can consider when determining what amount of pain and suffering to award, right? Things like fear, shock, anxiety, actual pain and suffering, future pain and suffering, loss to earn a living, and things like that. So those are all kind of separate items that the jury can start to think about when deciding what to award for pain and suffering.
Yeah, and I think, you know, there is an exception to the rule as far as the length of suffering goes, because typically we would think, all right, well, if somebody's paralyzed and they're going to suffer from that injury for the next 40 years, then obviously that should be a large award.
Sure.
But, for example, a wrongful death case, there's two claims. There's the value of the person's life to them, and then there's the estate-based claim. The estate-based claim also includes medical bills, it includes funeral costs, but it also includes the pain and the suffering that the person went through prior to passing away.
Right.
There have been some cases in the state of Georgia where someone passed away within a few seconds of the injury occurring, but it was a tremendous amount of pain and suffering that they went through in that small amount of time, and became aware of their upcoming death. And the award for that was in the 7 figures. Right. It doesn't always happen that way, but there are some exceptions to where somebody may suffer a smaller amount of time, but the award can still be large.
Right, exactly. And I think another thing, we've talked a lot about juries and them deciding, you know, what the pain and suffering amount's going to be. So one thing that obviously comes to mind is what venue your case is in and what the jury pool looks like.
For sure.
Right? Because there's conservative venues that don't think much about pain and suffering unless, I mean, you've got an arm chopped off or a leg chopped off. And there's other venues that will award, are typically known to award more for pain and suffering damages.
Yeah. We always ask the question when we're picking a jury during voir dire or jury selection. We try to feel out how the people that we're selecting from feel about pain and suffering damages. And almost every time that we select a jury, there's going to be a few people out there that say, I don't believe in awarding money for pain and suffering.
Right.
You know, they'll say, well, you know, medical bills is one thing, lost wages is one thing, but nah, pain and suffering, I don't believe in that. And of course, we try to make sure they don't get on the jury. But we run into that more in more conservative counties, or what we would consider traditionally red counties. And you know, you just have to take that into account when you're trying to decide what's pain and suffering valued at, you know, when you're trying to settle a case.
Right.
Like, where are we at? Where are we going to try this case? What kind of people are we going to try to convince to assign a number to an intangible thing?
Right, and I think too, a lot of that has to do, and another element we'll talk about is the injured person's ability to convey what it is that happened to them, what their injuries are, how it's impacted them, which is a very hard thing to talk about. I think most folks, just in general, by their nature, they don't like to talk about themselves. I don't like to talk about myself. And if I'm hurt or if I'm injured, it's hard for me to convey how that's actually impacted my life, right? But the ability to do that, and to do it effectively, truthfully, and in a way that the jury can connect, is going to have a lot to do with what they award for pain and suffering as well. Because juries can't award based on sympathy, but you've done a great job with this too in your closings, is they can try to empathize or understand where the injured person or the plaintiff is coming from, and having to deal with the injuries, the treatment, and whatever happened in the wreck. So that's a huge factor as well.
Yeah, and I think it's entirely up to the lawyer and the plaintiff and the client to work together to come up with some concrete examples of the way that this particular injury has caused them to suffer. Because it's not always just the pain and the suffering that's associated with physical pain, it's also mental anguish and the suffering that comes along with that. So, for example, we've had cases where, you know, it's a husband, there's a married couple, the husband gets injured, he is unable, but due to his injuries, from doing simple things that are traditionally man obligations in the house. Try to not get too much talk on my shoes with that, but you know, that men sometimes take pride in, mowing the grass and fixing things around the house. Hey, changing a light bulb. This guy had a shoulder injury, couldn't even reach up and turn his hand in this direction. So yeah, it hurt when he tried to do those kind of things, but the emotional pain of having to admit that he was too weak and unable to do those things and have to ask his wife for help was 10 times more powerful in the trial than him just getting up there and saying, well, you know, it stinks because I can't mow the grass, and it stinks because I can't do this. But he was able to convey that, and it gave me the evidence and the testimony I needed in closing argument to be able to try to convey to the jury that that's a really big deal in a man's life.
Right, and that brings up a good point too, because with any sort of injury and expressing how it's impacted you, it's always important to talk about what you were like or what happened before and then after, right? So we call those either before and after testimony or before and after witnesses. So you already talked about the client or the plaintiff giving that sort of testimony, but it's also equally important to have a spouse, a child, a parent, a coworker, someone to come in and testify, yeah, I knew Joel before this wreck or before this incident, and he was always up and jumping around doing things, but after this wreck or after this incident, after this back surgery, he's been a completely different person, right? So to have somewhat of a disinterested witness come in and testify on behalf of the client or the plaintiff gives the jury another perspective and another thing to consider when determining, okay, this really did have an impact, and not only did we hear it from the client, we also heard it from the employer or whatever it might be, to have that before and after witness. So
yeah, for sure, because if you were experiencing this type of pain prior to the wreck and it hasn't really changed after the wreck, then what is there to award? Right. You may have medical bills, but if your pain is the same, then arguably the defense has would have a good argument that there should be no award for pain and suffering. Just because you had pain before, you may have had pain before, but if this made it worse, you can still recover for the increased pain that you suffer from. But it's one thing, like you said, for the plaintiff to get on the stand and say it, because obviously they're involved in the case, right? Like
interested.
They could get something. Yeah, that's the word I'm looking for. Thank you. For helping me with my mastery of the English English language. But it's another thing to have people who don't stand to gain from any verdict come in and testify on behalf of this person. So it can be, a coworker, like you said. It could be somebody they go to church with. It could be somebody that they're in some type of civic club with. Obviously, if they're married, we're going to have their spouse, but
they're still interested as well.
They're still interested, but at the same time, they probably know more than anybody else on the face of the planet. And so you kind of have to walk this line of getting a good representation of different people that the plaintiff has come into contact with to come in and give specific examples. So yeah, I mean, those are the main things that I would think of that you're trying to consider when you're coming up with a value for pain and suffering. And it's just not one of those situations where you can say, all right, Chase missed work for 4 weeks and he lost $2,000.
Right. Yeah, there's no exact science, which is why, a lot of times we have to try cases because a lot of times we can't agree. Usually we can agree on what happened, right? I always use a car wreck example because it's the easiest. We can agree that there was a wreck. We can agree that you were injured and you have medical bills, but we can't agree on what that pain and suffering amount is going to be because there's no formula to get an exact number.
Yep.
So.
And I'm going to say this too. You may hear from attorneys at some point that there's this formula like 2 times or 3 times or 5 times or 10 times medical bills.
Right.
That is complete garbage.
Right.
Absolute garbage. You should not pay attention to that under any circumstances because it's completely different, right? If somebody breaks a rib and there's nothing that can be done medically other than taking an x-ray and say, hey, here's some pain medication, right. You're just going to have to suck it up until it heals. Well, the suffering from that $400 medical bill is maybe 100 times what the medical bill is.
Absolutely.
Whereas if somebody goes to the emergency room and they have 27 CAT scans done and they've got a $40,000 ER bill,
and they're fine,
but they're completely fine,
right.
Then the pain and suffering award is not going to be 10 times medical bills.
Right.
So you have to take it on a case-by-case basis. So if somebody just gives you this general formula, take it with a grain of salt because it's not going to apply in every case.
Absolutely.
So, all right, well, that will wrap it up for week 19 of our video series of 52 weeks of personal injury. If this video has been helpful to you, we'd appreciate you subscribing to our channel, giving us a thumbs up, or if you have any other creative ideas for valuing pain and suffering, past, present, or future, just put them in the comment section below. Otherwise, we will see you next week for video number 20.